Ready to go? I'm sorry. Emily, today we're going to discuss about the temporary protected status that they have given to people from Burma, El Salvador, Haiti, Honduras, Nepal, Nicaragua, Somalia, Sudan, South Sudan, Syria, Ukraine, Venezuela, and Yemen. These are all the people who are important. Some of these people have been given temporary protected status from 1999, that is Nicaragua and Honduras. Some of the country people like El Salvador is 2001, that's almost like 20 plus years. These people are getting the EAD and all those things. However, when it comes to the employment base, what about them? These are the people who have been maintaining legal status. The TPS people don't have to maintain the legal status, but our people are maintaining the legal status, our audiences are maintaining the legal status, paying the taxes. What about them? What is for them?
Yeah, unfortunately, this is an all too common theme with immigration. It's let's put out fires where we need to put out fires and not fix any of the things that are broken for the a large number of people that use this system, for U.S. businesses that rely on this system, for the employees that are helping build our economy in our country. We're not really providing any kind of good service to them and not letting them get their EADs because they can't file the 485 until the date's current. And then when it finally is current, the approval notice I got in the mail today, 13 months for an EAD. I mean, what is wrong with this picture?
Now,
for a physical therapist, this is a healthcare worker even, took 13 months.
Emily, I blame my fellow country citizens who came from India for this, Emily. The reason is that if something happens in Ukraine, though, they make a big noise on it. Something happens in Nepal, I mean, they make a big noise about it. They're more worried about the people that are outside what is happening. Now, how does, if Nepal, the things happen, it's very sad, we need to help them. Back in Honduras and El Salvador in 1999, I mean, back in the time when I started the office, you were not even working as a lawyer at that point of time, and that's when they gave them the employment authorization because they made a big noise. My country is going into hell, give me the EAD. But our guys don't make that much noise because they don't feel that they are going through hell. I don't know. I feel they are going through hell. Otherwise, why are they listening to our video every week? But they don't voice that much. That's my concern, is that they need to make it as an important point as a community that Indians who have been discriminated the most of all the base immigration, though. When I go to the cultural organizations, when I go to this religious organization, nothing is commented about it. They are, the movie star comes in, everything falls apart. They have like movie fan associations. They have rallies going on, thousands and thousands of cars rally for some political party that is in India, in one particular state though. But when it comes to their own legal status, I don't see them voicing it out. I don't see them coming on the streets. I don't see them protesting. I don't see them writing the letters. But they're interested in movie associations or some political party in one particular state, and they're like, whatever the party might be, I'm not taking that those parties are good, but there are thousands of our cars are rallying though. They get the permission from the police to do that. Why can't they do it for the delay in the immigration though? Why can't they write the letters? Why can't they make sure that all these cultural organizations that belong to India address these things? So they're more interested in which movie star is coming, but they're not interested in the immigration. How can we help them? Look at how El Salvador's are united. Look at how Yemen people are united. Look at how all the other country people are. There something is happening. They are pounding on it. They're getting other people go to this Washington, D.C. to protest. In fact, when I was in Washington, D.C. 10 days ago, there was a big protest about Ukraine and other things. But I don't see our guys doing that thing. Anything on that?
Yeah, and that's, that's all we can do at this point. We've been fighting for these, the fairness for high-skilled workers, eliminating the cap. That bill has been introduced so many times and never moves forward because there's not enough noise made about it. It's something that most people are just not aware of because we're not sharing our stories, we're not reaching out to media, we're not doing any of these protest activities. We're not sending letters, sending editorials. I'm starting to see some more activity happening more on the legal dreamers. They're the ones that are starting to move this forward and talking about what's going to happen when they age out, and that there should be protections for people who basically grew up here and were here legally the entire time. And they shouldn't have to self-deport and those sorts of things. I see that happening much more than I see
the employment base.
Yeah.
Now, I know you addressed about the Congress bills and all those things, where things have to. They wasted 70,000 green cards last year. They are on a path of wasting 150,000 green cards this year, and our guys are not interested in writing the letters. They come to file a writ of mandamus. Well, we can't do that. We have failed many times in that thing. If we could do it, we could go to court and get it done for you and make money for ourselves too. Nothing wrong with it. But if we cannot do it, the only way we can achieve it is that by forcing you to write the letters. That's all we can do. So the reason why these people are getting employment authorization, even though they are not legally present in the country, is because they are making the voice. And while our people are eligible legally to get the employment authorization, they don't get it because our guys are not making the noise. I cannot have any more conclusion than this. I will leave up to you guys. If you're not writing a letter, I don't know what to say. We have created the drafts of the letter for you to write to the congressman, write to the administration to adjudicate the applications. So at least we don't waste the green cards that were been already allocated to us. Emily, with regards to the adjustment of status, how do the USCIS adjudicate the application? Is it first come, first serve, or not?
I think they would claim it's first come, first serve. But if you just look at the data just from our, one attorney in our office that publishes that on immigrationgirl.com.
That's me.
Very clear that it is not first come, first serve. When we have applicants who are still pending from October 2020, yet applications filed in January 2022
gets approved. October 2021 gets approved, but October 2020 never gets approved. Do they consider priority date? Let's say, for example, my priority date is June 2010, and the other guy's priority date is July 2011. Will they give preference to me?
I don't think so. I think it's all they look at is their visa available, and if it's available for both people, then either one could be first. They're not going to prioritize them in that order, which to an extent makes sense when people are recapturing old priority dates. It would give them the ability to jump in line ahead of people who maybe filed later, but still the green card is available for them. So it's not based on priority date from what we can tell. I don't know how it's not based on first in, first out. It's just luck.
Pure luck.
Pure luck.
Pure luck. I will tell you some of the things that we have noticed though. People who have filed I-140 along with the 485, mostly for the downgrade applications though, they were being very slow because they ended up in Texas Service Center or Nebraska Service Center. The people who filed solo 485 application that most probably ended up National Benefit Center directly, they ended up getting the approvals. The other batch of things is that the people who filed in October, very early in the October of 2020 and now November of 2020, it took 4 months for the Texas and some parts of the Nebraska Service Center to process it though. But when it comes to solo filing though, which ended up National Benefit Center, they got approval much faster. In fact, when I look into the stats of the applications that were approved in March of 2022 though, from my office desk though, almost 95% of them were actually approved by the National Benefit Center though. And to astonish though, what I notice is that most of the cases, that means more than 50% of the cases, were actually filed on or after September of 2021. While I have more number of cases from my desk that we filed in October of 2020. So they ignored October of 2020. They started approving the September and October of 2021. There is no logic. There is no first come, first serve. There is no responsible person there. And unfortunately, we cannot take them to court. We have tried many times working with other lawyers, by ourselves too. We failed because the judges are not willing to take this. They say that they do not have the jurisdiction in the adjudication process of the I-485. So any further cases will most probably will be denied. The only solution that what we think is that you keep writing the letters though.
All right. Additional news that came out with EB5, now that that has been reauthorized, in that bill that reauthorized it, we have a new provision that would allow someone to actually file the adjustment of status along with the I-526 application. Prior to now, you had to wait the several-year process of that 526, even if a green card was available in EB5 based on your priority date, you had to wait for that approval before you could file the 485. So, and that 485 is often needed for people to get the employment authorization to actually be able to manage their investment. But now you'll be able to file the 485 along with the I-526 if the priority date is current. If your I-526 is already pending, you can actually file the 485 now, or since the dates are current. So that's a good thing for the EB5 investor program that I think not a lot of attention has gone to. Another update that we had this week was from the SEVP program, sending out emails to some F1 students basically saying that you need to update your employment data in the system. Apparently, we had the SEVIS system and the SEVP system, and the data between the two are not aligned 100%. And so for some students where it's not in alignment, they have sent emails saying you need to contact ICE either by phone or by email by May 16th in order to update the employment information for those that are on the OPT after they graduated.
Let's go to the questions, Emily. I have this question. Ranjit got the green card. Have been listening to us. Thank you very much. Hope wish you best of luck in your future endeavors. But don't forget that even though you got the green card, please keep writing these letters for the people who are down the line. They still deserve to get a better thing. They don't deserve to be waiting just like the way you've been waiting for such a long period of time, just because you are born in one particular country though. Let's hope that you will fight for it and you will continue fighting for these individuals, and you will not forget Ranjit. And wish you best of luck in your future endeavors. Raj wrote the letters to the congressman. Thank you very much. The prior date is 2013 in EB2, and my perm recently got certified. Should I apply for I-140 and 485 together or separate? Good question, Raj. I will not file your I-140 and 485 together. I will file your I-140 in premium processing. You still have until May 30th to file your 485 application. If I get your I-140 approved by that time, I will attach the I-140 approval, and by any chance, if it's still pending by that time, or if there is any RFE though, by May 20th, I will file your 485. The reason is that you can still file the 485 application with the receipt notice. You do not need an approval of the I-140. And why would I take the strategy of not filing together? Because if you file your application together, it will end up in our dear Texas Service Center or at the most Nebraska Service Center. And by the time they move your application to the National Benefit Center, the priority date may or may not be current for you.
Abhiram has written a letter and wants to know if he has an H1B extension pending with one employer, can a concurrent H1B be filed by another employer while it's pending? I have not tried it based on a pending extension, and I think there's some risk there, because if for some reason that extension gets denied, your concurrent petition would likely get denied because there's no petition to be concurrent to. So I think it'd be a better situation to get the extension approved first and then file the concurrent employment. He also asks, he heard sometimes USCIS will inform the first employer about the concurrent petition, and that's not true. They have no reason to do that. They're completely irrelevant. The fact that a concurrent petition is filed, that's between the concurrent employer and USCIS. The first employer has no issue with that at all and would not be informed by USCIS.
Vinny, Alex is telling, do you guys still recommend refiling? Now we are I'm a bit neutral on it. Emily is like maybe more towards refiling, but it's a case-by-case analysis. We have put a separate video just on that. You may want to look into that, whether or not refiling or interfiling, which is more suitable for you though. Ranjit is telling he has written many letters. That's very good. Ranjit, thank you very much on that, and that's good. You've got the green card, and most of other people have also benefited. These letters, people say that, do they actually benefit though? Now you look into the USCIS statements on the Twitter right now. Look at the USCIS policies that they are trying to change though. They are definitely indicating that they want to adjudicate the more applications. It's just that they are not able to, but that's a different issue, but they're trying to adjudicate as much as possible. And also, if you look into the first 3 quarters of the 2021 fiscal year that ended up in July of 2021 though, as compared to August, September, that ended up in June, and July, August, and September. In July, August, and September, in those 3 months, they adjudicated more applications than what they adjudicated in the first 3 quarters. So we can see that the letters did work though. I mean, we have seen State Department addressing when we told people to write the letters. Out of the 1,200 letters, seems that 800 letters came from ours and TV Asia channel, which me and Emily are part of it. So definitely these letters will help and will, what else can you do? I mean, letters are the best thing that you could do to explain. And people are asking question where we can get a draft of it. It's there in the link. If you go there and you have expand the message there's a link that is provided, and you can follow the link, and the letter formats are there for you.
Sue Robbie has written a letter to her Pennsylvania congressman and wants to know, per the phone agent, my case was moved from the NBC to a non-local field office and back to the NBC. Dependents are still at the same non-local field office, no RFEs. Any idea what is happening? No, I think USCIS is quite inefficient. I think they have a lot of glitches. I think a lot of things fall through the cracks, and it sounds to me like this may be a case where that fell through the cracks, where either they didn't issue a transfer notice for your dependents, but they did actually move, or they forgot to send the dependents along with the main applicant. We've seen a number of cases where the dependents have been separated from the main applicant. Main applicant gets approved, dependents are still pending for some time after the approval. So it's not unusual. I don't think it's the correct thing that they should be doing. I don't think USCIS knows what it's doing for the most part, and they are just making these kinds of errors all over the place.
Nandan Shah from Facebook has written the letters to the lawmakers. Thank you very much. EAD combo card has been arrived. 180 days are over. Can I keep my current H1B with current employer, start a non-physical therapy business? Hopefully, sir, you're a physical therapist. That seems to be fine. Can I maintain the H1B status? Now, once you do job, which is doing a business and working in other than your employer though, you're definitely violating the H1B status though. Do you need to do a 485J supplement if you're doing a side job? No, you don't need to file a 485J supplement. Now, if you have the EB2 priority date is, and you have the EAD card, I don't know if I would maintain the H1B. If you have other great ideas that you want to, I'm not sure if I would maintain the H1B status though. Nandan, I have to tell you that at one point of time, I was a dependent of a physical therapist. My wife is a physical therapist, and I was a dependent on her, and I got a combo card. I got an EAD card at that point of time. And I personally myself let my H4 status ruin and started working on the EAD card myself though. So that's what I did at that time, and if given a choice right now, if I'm in that situation, I will do it again. In fact, I was an immigration lawyer on the adjustment of status EAD. I was a dependent on a physical therapist. So yeah, I did as an immigration lawyer on an EAD letting H4 go. And what would I advise other people if I've done myself? You can take a judgment call on that.
Manoj has written a letter and said he filed the downgrade to EB3 in October 2020, planning to refile in EB2, and wants to know if he can continue to use the EAD and AP he received from the EB3 to avoid applying for the EAD and AP again with the EB2. So when you say continue to use, make sure that you know that when you refile, you have to be in a non-immigrant status. So if you've used the E80 AP from the prior 485, you need to get back into non-immigrant status before you can refile in EB2. I would say that, number one, there's no guidance from USCIS on what happens when you have a second 485 filing, and is each E80 AP tied to one or the other? There's nothing out there that says one way or another on that. Another thing I would say is, why avoid filing the second E80 AP? It's free. There's no filing fee for it. If you're going through all the hassle of preparing a new 485, getting the new medical, getting the photos for the 485, just get 4 more photos and include the E80 and AP along with it, because there's no additional cost to that. Now, in the cases that we've refiled, in some of those cases, they have closed the second E80 AP application without approving it all, saying that you already have this benefit, so we don't need to approve this one. That happened for some people. Other people got the second E80 and AP. So is the first one tied to the EB3? We don't know. I think there's a strong argument that can be made that you are eligible for an E80 and an AP by the virtue of the fact that you have a pending 485, you happen to have 2 pending 485s, but we don't know, unfortunately. There's no guidance from USCIS on that, so you have to take a calculated risk if you're going to go that route.
Good question from Ganga from YouTube. If the 485 has been filed along with the receipt notice of I-140, will it be considered as a concurrent filing or standalone application? It will be considered as a standalone application, even though your I-140 is not approved. The reason is that when you file an I-140 and 485 application together, though, the I-140 has to be adjudicated on the current processing way in either Texas or in Nebraska Service Center. It cannot go to National Benefit Center, though. That's the reason when you attach I-140 with 485, it will end up in Texas or Nebraska. When you have a receipt notice and you file the 485, it will go to National Benefit Center. So it will be considered as a standalone application.
Sweet Seller has sent a letter to Tennessee congressman and got a generic response with nothing specific. That's normal, nothing to worry about. Doesn't mean that they're not reading them or listening to them, but obviously they just give a generic response. But he wants to know, why does the USCIS list the Vermont and California service centers under the 485 processing times? Do these service centers actually process EB1, 2, and 3 cases, and can they be moved there? They don't process employment-based EB1, 2, or 3 485s, at least not that I've ever seen. They had kind of split all of the service centers a long time ago, back in early 2000s, what they call it, by specialization, where Vermont and California were focusing on the non-immigrant, the I-129s, the I-539s, and Texas and Nebraska were focusing on the immigrant process. And then we added in the National Benefit Center, and then Texas and Nebraska do H1Bs now too, so there's no more by specialization, but the 485s generally don't go to California or Vermont, and I don't think we want that because they're not that great either.
Can USCIS approve refile case pending at National Benefit Center while downgrade I-140 petition at Texas Service Center? Absolutely they can. There's absolutely no doubt. You have an I-140 approval. It's a completely independent application. It is not an interfiling, so I don't see any reason whatsoever at all holding your refiling application with the approved I-140 under EB2.
Bharat, who wrote a letter, said, my case status says it was transferred 3 days ago, but when I called USCIS, they say it's still at TSC. How many days does it take to transfer from Texas to National Benefit Center? It's possible that when you called USCIS, they didn't know what they were talking about. Typically, when you call and actually talk to a live person, that first live person can only tell you the same thing that's on the USCIS website when you plug in your receipt number for the case status. So if you plug in your number and it says transferred, and the person that you call is saying it's not transferred or it's still at Texas, I don't think they have any way of knowing that. Without going to a tier 2 officer, or you wait for the callback that happens in 2 weeks if you're lucky. So it's very likely that it has transferred. Now, how long does that transfer process take to complete? Nobody knows. That's all internal workings with USCIS. They are apparently shipping them every week, so maybe a week. I don't know.
Every week, 1,000. Nanda has this question. I'm changing my employer and my wife's H4 EAD is expiring in September 2023. Can I file again H4 EAD with a new employer right now? The answer is yes, Nanda, you can. You should, because you know government is taking its own sweet time in approving the H4 EAD. Now there comes the million-dollar question. These lawyers who read the books and they don't practice law, I don't know what they do, and they tell you that, oh, the book says that you can only file the EAD within 180 days. Damn with them, you can still file the H4, you can still file the EAD, even though it is expiring in September 2023. We have never seen any H4 EAD denied because it was filed for more than 180 days before. There were one or two RFPs we have seen once in a while. We responded to it. We advised them how to respond in some cases, and they got their EAD's approval. So I would strongly recommend to apply for the H4 EAD and H4 extension right now, because if you wait until March of 2023, you file the EAD extension, and these baklavas will never approve these EADs by September 2023. So your wife will be out of job. I recommend to apply right now.
Nandon has written letters to lawmakers and says, I have an EB2 combo card, 180 days are over. Can I keep my current H1B with my current employer and start a business on the side while maintaining the H1B status? And do I have to file supplement J for this business that I want to start?
I think so. It's a
You
physical
already got
therapist.
that one?
Physical therapist. Right?
Yes.
Yeah, I got it.
Okay. You said you already answered that one?
Yes, yes. My I-485 is filed under approved with Arizona Service Center. Is this going to adjudicate fast? I don't know what Arizona Service Center is. Now, that's I'm assuming that it's Nebraska Service Center though. Well, if your I-140 is approved, that's definitely a good signal. But I don't know where your application is. Does it start with MSE? Does it start with LIN, or does it start with SRC? Depends on that though. And most right now, the LIN and SRCs are not getting adjudicated in their respective offices. They're getting transferred to the National Benefit Center. If your starts with MSC, that means it's a National Benefit Center, it most probably will be adjudicated fast. Or if it's been transferred to National Benefit Center, you have a greater chance of getting your green card approved faster.
Sai Krishna says, I want to go to India for a small vacation, but my visa has the annotation accepted from or not subject to PP 10052. Will there be any problem when I'm coming back at the port of entry? So that's referring to one of the presidential proclamations that were issued during COVID that restricted consulates from being able to issue visas, either because of a COVID ban or when we had the H&L travel ban for a while there. All those proclamations have been lifted. So even though you got that visa because you didn't need to go, you weren't subject to one of those proclamations, because the proclamations are lifted now, it's completely irrelevant, won't cause you any difficulties at the port of entry.
People are asking a question with regards to the National Benefit Center. We don't see the processing time. How do we judge our processing time when online it's not listed there? Well, if you are filed in the National Benefit Center, you need to look into the particular district where you are located at. If you Google out though, USCIS has the provision where if you put the zip code, it will tell you which district office you belong to. Then when you go to the processing time, you have to look into the processing time of that particular district. Let's say you are in Austin though. Austin falls under San Antonio. So what you do is that you then go to San Antonio, check the San Antonio 485 timings. That is the timings for you. Now, if the timing crosses though, you can raise a service request saying that, hey, it's San Antonio timing is December of 2020. I filed in October of 2020. You can raise a service request that is a better strategy for you.
Joby has a question on the Child Status Protection Act and interfiling and wants to know, will my kid's age be locked again under the EB2 category once the interfiling request has been submitted? The final action date is current in EB2. So I don't think we have any guidance from USCIS on this, but I think how they're treating an interfile is pretend that you are filing a second 485, because they're saying you have to meet all of the eligibility requirements at the time of the interfile request. I think that's why they're saying the 180-day clock starts over for AC21. So if we go under that assumption, then yes, assuming your final action date is current on the day the interfile is submitted and your I-140 is approved and the child's age is under 21, then it should continue to be locked if it was already locked under the EB3. If it was not locked under EB3, it should be locked under EB2 because basically how USCIS looks at it, they don't look at when you file the 485, they look at what is the child's age on the first day of the month that the final action date is current when you subtract the number of days the I-140 was pending. And as long as that's under 21, the age is locked.
Nitin Soma tried to enter into Mexico. They said, hey, you need to have a H1B stamp in the passport or GC to enter into Mexico, not advance parole. That's rare. We have sent many people. We never had any problem. I don't know why they have a problem with you. You can do one thing. You can go online and there is a visa there. You can apply the visa online, a Mexican visa, and based on that, you can enter into Mexico. That'll be easier for you. You can do that online step before you enter into Mexico. Nandini has his question, Vaishnavi has his question. She interfiled in California in February. Well, as directed by USCIS, you did it. Can I raise a service request because of out of processing of 485J supplement? Wow, good question. First of all, we don't have the 485J processing time anywhere published. So yeah, you can try. If it works, let us know. If it works, let us know.
Anoop has written a letter and he wants to know, whenever I try to submit a service request online, it says bad gateway, try again. Is there any solution? I've not come across that. The best thing I can suggest would be to try different browsers, try different computers. It could be that although online it shows that your processing time is outside the normal processing time, they're internal, they have different numbers internally, and sometimes even though it says outside normal processing time, they say it's really not. That could be the situation as well, but usually you'll get a message saying that your case is not outside normal processing time, we can't do a service request.
I have a pending asylum application applied for TPS. Can I apply for adjustment of status? Priscilla, our office is definitely not well equipped with the people who have applied for pending asylums. So definitely we're not in that field. I would recommend that you contact other lawyers who are proficient in that particular field.
Kishore has the AOS, EAD, and AP filed an EB3 at the National Benefits Center, but the date has retrogressed, and he wants to know, can I still expect my EAD irrespective of the retrogression? It's been more than 180 days. Yes, the EAD and AP both, you're eligible for it simply because you have a pending 485, even if the date retrogresses after you filed that 485. It can be retrogressed for 10 years and you're still eligible to keep renewing your EAD and AP every 2 years the entire time.
Poonam, I got my EAD from Nebraska. Would my 485 still be transferred to NBC or will it be processed in Nebraska since my file was touched? First of all, by getting an EAD in advance parole does not mean that they touched your 485 application at all. They adjudicate the application without looking into whether you're eligible for approving for the 485 application, which is sad. I mean, they should have adjudicated the 485 instead of EAD in advance parole. It should still be moved to the National Benefit Center unless an officer has already reviewed it. Definitely getting an EAD in advance parole doesn't mean that they have reviewed it.
Harry has written a letter and wants to know, what does the ETA case number listed on my I-140 approval notice mean? It starts with an A and has 10 digits. That's actually your PERM case number. So when the PERM case is filed, it's with the Atlanta National Processing Center. That's what the A stands for. So your PERM case has that A number with the multiple digits. I don't know why they use A and USCIS uses A. Someone should have told them not to use the same letters there. But they did start putting that number on approval notices a couple of years ago.
Shruti Agarwal has this question: can I use my EB3 EAD AP? I've refiled EB2 India as well. My husband is a primary applicant. I'm the derivative. It's a tough question, Emily. I'm taking the stance that if people who have filed an if the people have filed an EB3, got the EAD, now you filed an EB2, should I use the EAD application? I'm taking a stance that you're at 10% risk if you use the EAD of EB3, that they may say that we will get you stick with the EB3 application. That's what do I have any basis to say why it's a risk? No, I don't. Actually, I don't. I'm just imagining that there is a 10% risk, because I've seen people who got approved, even EB2, even though they use the EB3 EAD approval. I've never seen any of them saying that, you're going to get stuck with EB3, but I'm just making this up 10% chance because they may, you never know how the things will change.
Yeah, because there is no guidance. That's the difficulty, is we're in uncharted waters. So we have to kind of predict all the different horrible things that we think USCIS could do and hope they never do, just so that everyone is aware of the potential risks and then can make an informed choice on that. But yeah, I would say it's a relatively low risk.
Zorwar has this question: I'm a part of non-profit social cultural organization here in USA. Does it create an issue with H1B stamping when I mentioned that in the DS-160? No, that should not cause. If it's for social cultural organization, that should not. Like, for example, there is something called Telugu Cultural Association. There's something called Meenakshi Temple. There is a masjid. There are different things, and if you're a part of it, that should not cause anything at all, because those things like going to temple and other things, they are for non-profit purposes. People don't get any monetary benefits there, so that should not cause any problem in you getting the H1B stamping.
Chintan has written letters and says, I have my approved I-140. My wife's H4 EAD is in process. What is the impact on the H4 EAD in case I change jobs? So there should not be any impact when you file that H1B transfer, but we have seen from time to time that there is, even though there should not be. What typically happens is after you transfer and join the new company, the old company may withdraw your approved H1B, which is what they're supposed to do. But that withdrawal has sometimes triggered USCIS on the H4 EAD. Had one or two cases where they just flat out denied it. In other cases, they sent an RFE asking for proof that the H1B holder was continuing to maintain status. So you have a couple of options. Number one, you can file another H4 and EAD along with your H1B transfer to be on the safe side. Or once you get your H1B approval notice, you can interfile that approval notice to the service center where both the H4 and EAD are pending, and ask them to adjudicate the H4 and EAD based on your new H1B approval notice.
Shilpi has this question: can I travel to India after refiling if I travel with an interview appointment at embassy for H1B? Absolutely not a problem. You can definitely do that thing. Rajesh from YouTube has this question: I have a perm in EB2 approved with old employer. If my priority date becomes current in EB2, can I move to old employer and file new I-140 and 485? One doubt that I have is, when was your perm approved? Was it approved more than 6 months ago or less than 6 months ago? If it's less than 6 months ago, yes, you can file an I-140 and 485 application. But if it was approved more than 6 months ago, then have you ever filed an I-140 with your old employer? If it was approved, let's say in 2018, the perm labor has been approved, you never filed an I-140 application with them, and now you're with company B, can you now go back and join and file an I-140? Absolutely not. But if you have already filed a labor and I-140 approval with them, and then later on they have withdrawn the I-140 application, and now you have joined company B, you can go back. Once the I-140 has been filed with the previous perm, though, the perm becomes valid perpetually, forever. That means that you can use it to file an I-140 again. So that's the main criteria to see, is that if you filed an I-140 previously with a bond.
Kishore has written a letter and says, I'm a straight EB3 applicant, 180 days has passed. Can I change employers without impacting the adjustment of status? Potentially. Number one question would be, do you have your EAD, or are you planning on filing an H1B transfer? And number two, is your I-140 approved? Although that's not a mandatory requirement, we do recommend that because it reduces the risk of running into trouble with the AC-21. So if your I-140 is approved and you have the EAD, your 485 is pending for 180 days, you are eligible to change jobs by submitting the supplement J, as long as the new job is similar to the job that you were originally sponsored for.
Abhijit Sen has this question. He sent a letter to the congressman. Thank you so much. Is USCIS process renewal of the EAD within 3 months? Is it bound to approve within 12 months because it's an extension and it's an interim benefits? It is supposed to be bound by. But if they don't, though, you can sue the USCIS. Definitely, I would recommend to wait until 6 months. If it doesn't get approved, you should sue USCIS. And if you want to contact anybody in our office, though, that will be Stephen Brown. He's the proper person in our office for you to contact for suing USCIS. You can make an appointment, and we have given a link to it. Not me, not Emily, but Stephen Brown in our office.
Wahid has written letters to both USCIS and congressmen and wants to know, will there be any spillover next fiscal year? I do think there may be some, given that consulates are still not operating fully. It's very possible they'll waste some family-based green cards again this year, just like they have the last 2 years. And that is what would create the spillover. Will it be anywhere near the level that we had this year and last year? I don't expect so, but there may be some.
Rashi Kumar says that, can I bring my spouse from India and GCEAD? I'm getting married in June. No, unfortunately not. If you want to bring on GCEAD, you have to come back. You have to first get the green card. God knows when you're going to get it. And then you have to file a following to join. And once you've, and after the following to join is approved, they will come into the United States. You can even file F2A. So after you get the green card, the processing might take anywhere between 1.5 to 3.5 years for them to come into the United States. If you want to get her immediately, though, my suggestion is that if you already use the EAD, your company can still file the H1B for you, and you can get the H1B and H4 stamping in June and come back into the United States. That's one way of doing it. If you have not already used the EAD, then you continue to be on the H1B until your wife comes here, and after she files a 485 application, you can kick your H1B out after that.
Harsh wants to know, is it possible to get a 3-year H1B extension if the approved EB2 I140 final action date is current, but an approved EB3 I140 date is not current? I don't see any reason why not. I would not be submitting the EB2 approval notice because it's not relevant, but you can submit the EB3 I140 approval notice that's not current to request a 3-year extension.
Vijay Raghavan has this question. His priority date is EB3 2017. Can I change jobs? Tough question. Can your company not file the 48? Can your company not file the EB2 application? That's one thing that I would suggest your company to do it. EB3 2017. That's a tough choice, though. That's a very tough choice, though. I do not want to predict the priority date of the moves. I went wrong so many times. In fact, I claim that I've gone so many times wrong. Nobody can beat me the times that I've gone wrong in predicting the priority dates. Mukesh has this question. How long does the USCIS take to respond to the ombudsman request? Typically, it will take about 30 days to 90 days for them to respond. Sometimes they respond, sometimes they don't respond. Is it effective? One thing I would say that it does not harm you. For sure, it does not harm you. If it falls out of the line, let's say the processing time is September of 2020 and your application was filed in July of 2020, I would raise an ombudsman. It's just an online application for those people who don't know what an ombudsman is. You can go to Ombudsman, Department of Homeland Security, Case Assistance. And you can Google it and you will find it. You can fill an online application. My application has been pending from July of 2020. The processing time is September of 2020. So then then Ombudsman will contact the USCIS office and then will let you know about the process. It doesn't harm you under any conditions. So I definitely would like everybody's who falls beyond the processing time should use the Ombudsman's office to get their case adjudicated.
Renjit wants to know, by filing the FOIA request for an I-485, does it show that it's attached to the EB3 or EB2? And if the interfiled medicals are attached? It may, but the question is, how long do you have to wait after you have submitted those for it to be attached and come out in the FOIA request? I have seen where people request the FOIA sometime after they've done the interfiling of the medicals, and they do show the the medicals in there, so it's possible, but we don't know what that time period is for when you should make the request.
Rajshekhar Shanmugam has this question. He wants to change the job at EAD. Does a 485J supplement has to be filed before joining, or can we file later on? There's no rule that says that you have to file before joining. We do recommend it at about the time you join, you have to file, but not if you, let's say, for example, if you file after 2 months after joining, will they penalize you? Will you deny a 485? Absolutely not. You have to still stick to the requirement that when you change the job, it has to be after 180 days after you file the 485 application. But there is no need that you have to file before joining. For example, if you want to move from company A to company B on H1B, you have to file the transfer application before you join the company. But in the 485J supplement, they are very liberal. You can file it after 10 days, 20 days, 30 days. That's perfectly okay.
Saba says, if my date is current but my previous employer will not provide the supplement J, can I still file the 485? The I-140 is valid. Unfortunately, no. And if you did file it, you would just get an RFE asking for the supplement J, and if you don't provide it, they would deny it. So we definitely would not recommend filing an I-485 when the supplement J is required and you don't have it, because you do need the employer's support for your 485 application.
Ruchi has this question: which location green cards are getting printed, and how long it takes for the green card to arrive after the green card approval? I don't remember, Ruchi, at this point of time where it's been printed though, but one thing is for sure though. I have seen the green card approvals, that the green card cards coming very, very, very fast though. Sometimes in 2 to 3 days after the green card is approved. So perfectly, very good timing right now to get the green card. It is not taking much time at all to get the green card approved. Now, I've seen in some cases taking 10 to 15 days right now, but I've not seen much more than that now. Before, about 2 years ago, it was taking almost 2 months to get the cards. So, but right now it's just anywhere between 2 days to 15 days.
Alok says EB1C I140s are moving very slow at the Nebraska Service Center. Is there any specific reason for it? There's no reason for it. They've been slow for probably the last 2 or 3 years. Even before COVID, they were taking
probably
a year to process. Yeah. Now maybe they were gearing up for their premium processing fees that they'll be getting starting in June, hopefully, because premium processing has been expanded to EB1C I140s. So that should help, but it shouldn't be required to have to pay a lot of extra money to get normal processing, but that's just how it's been for a long time.
Some people were asking questions. They work for the government. Can they expedite the 485? That cannot be the sole reason to expedite the 485 process, though. If you work for healthcare industry, though, the EAD definitely, if you're hands-on on the patients, definitely might help you in getting the EAD approvals faster, but not the green card in general. We haven't noticed it, though.
Keyshore's written a letter and says, on L1 status, have the EB3 I140 approved. AOS is pending for more than 180 days. Haven't received the EAD yet. H1 was picked in a lottery through the different employer. Would you file the H1? I think I don't see a problem filing the H1 in consular processing because you have been selected in the lottery, and that way you can choose when it might be a good time to take advantage of that. But doing a change of status to H1, that means you're going to be out of L1 status come October 1st, assuming it's approved, and no longer able to work for your old employer. So that may be a problem.
Question with regards to the EB1C green card application, that if the EB1C application is still pending and the L1A expired and EAD is not been approved, can I stay in United States because of the pending 485 application? The answer is yes, you can stay in United States while the EAD application is still, and adjustment of status application is pending. Now, you cannot work because your L1A expired and your L2 EAD expired, but you can still stay in the United States while 485 is pending.
Bangaroo says, my spouse's H1B was not picked this year. Can her employer file her H4 and EAD? I have my approved EB3 I140. Her OPT expires January 2023. H1B renewal is due December 2022. Yes, so it's not something the employer would file. So either she would file it or she would work with your company's attorney to file it. And yes, she can do that based on the approved EB3. You may probably want to consider first filing your H1B extension and getting that approved, and then filing her change of status to H4 and EAD, since her OPT is expiring later. That way she'll get the full 3 years of the EAD instead of just getting an EAD that expires in December.
Uma has this question. I have to laugh about this question. She has written letters to the Tennessee Congress people. If I chat with Emma every day, will it cause any harm? Will they transfer my application to National Benefit Center? No, just because you chat every day, they will not transfer your application. If you're interested, why don't you speak with the Siri? Why don't you chat with Amazon? What is that? Amazon?
Oh, Alexa.
Alexa. Why don't you chat with Google? That's maybe better rather than chatting with Emma. I don't know if they collect all the data and then come and say, hey, you've been chatting too much with our girlfriend or something. No, I don't know. But yeah, I would recommend that you chat with Alexa, Google, or Sri rather than chatting with them. Avoid the government website. If you chat, they do collect the data. So I recommend definitely not chat every day with them. Anything else, somebody?
I'm trying to find people that have written the letters.
Yeah. When would they start the premium processing for EB1 I140s and EADs? We know for sure the F1 visas and EB1 I140s are coming pretty soon. So it may come anywhere between June to September. That's our expectation. There's no proposal for EAD except OPT EADs right now. Don't assume that the adjustment of status EADs, H4 EADs are not on the menu right now. They may come. We don't know when in the menu. Right now, OPT EADs, F1 and I140 premium processing for EB1C and national interest waiver are on the menu.
Pritam says, I need to travel to Canada on an emergency basis. With the H1B is expired, but I have a valid I-94 and 797 and no visa stamping appointments are available. Can I use automatic revalidation? Yes, assuming that your trip to Canada is for less than 30 days and you don't go for stamping and you have a valid I-94 but an expired visa stamp, you can use automatic revalidation to come back in the US. They treat your visa as if it's valid. They revalidate it at the time you're entering just so you can enter it back into the US.
Oh, this is a tough question. Sometimes I get these things. LG. Wrote letters. So wrote letters, we need to try, we'll try to prioritize people who wrote letters. Thank you very much. His priority date is April 2015. He got an offer, the new company filed a H1B. Should I join the new company right now? Wow. April 2015. As Emily was pointing out before though, that priority dates, There are some excess green cards that are going to come next year. That means October of 2022, all the way to September of 2023 though. So definitely that's a very hard choice. I will not tell people what to do because, as I said, I have gone wrong so many times, but I can tell I'm still very vocal. I like to be opinionated, and I am giving answers from deep in my heart, but I may go wrong, and I have gone wrong many times. If I were you, I would not move the job right now. I will wait until June of 2023 before I make any decision on changing the job, if my priority date is April of 2015 under EB2.
Suresh has written a letter to his Arizona centers and says, my daughter is 18, and if I get the EAD and AP before she turns 21, is she fine? The issuing of the EAD and AP is completely irrelevant for determining whether your daughter will age out or not. What they're going to look at is what is her age when your final action date becomes current on the first day of that month. Is it under 21? Then she's fine, assuming your I-140 is approved. If she's over 21, then they'll look at how long your I-140 was pending, and they subtract that from her age. And if that puts her under 21, then she's fine and locked in. But the issuing of the EAD and AP is irrelevant because they can issue that based on the filing date chart if you filed your 485 based on that. And the filing date does not lock in the age for Child Status Protection Act. Only the final action date becoming current locks in the child's age and an approved I-140.
Pradeep, his priority date is March of 2012, and he filed for it in October 2021, got the green card in 173 days. How can I help other people? That's very nice. Thank you. Keep writing the letters. Just change the wordings in there. You'll be in a good position to do that. And this is one of the things that we noticed, that people who filed in October of 2021 are getting more approvals than that of October of 2022, most probably because you filed an application, a straight application. You know, what happened in our office was in October of 2020, though, we were very busy. We were unable to take the outside clients at that point of time. And come October of 2021, we hired and we programmed, we did all the different things, Emily and I did a lot of different things to do very efficient 485 application. We got a lot of clients that we filed in October of 2021, and these people whom we filed in September, October, November of 2021 are getting the approvals, and they're spreading the word. Oh, Rahul did a miraculous job and I got my green card, and the people who filed in October of 2020 with the other law firm did not get the green card. No, there is no truth in it. We didn't do anything miracle, guys. It's just the USCIS acted that way. Nothing to do with our office at all. The previous lawyer who filed in October 2020 was also a very good lawyer. We also consider ourselves to be good, but I don't want to blame the October 2020 lawyer because the applications we filed in September, October got more approvals than October of 2020. It's how the USCIS is acting right now.
All right, well, I think we're out of time today. Thanks so much for joining us. As always, we'll be back next Tuesday at 5 o'clock Central Time. And don't forget, you can subscribe to our newsletter at rnlawgroup.com or at immigrationgirl.com. You can subscribe to get all of the latest updates whenever I post an article there.
Thank you very much.